Okay. Meeting will come to order. Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to said executive session or at the next meeting thereafter. An executive meeting was held on June 22nd, 2016 to review matters that are by statute 65 PA CS 708, 1108, 13A08, confidential, including a review of a confidential opinion report, a review of completed investigations for the purpose of issuing final adjudications, a review and consideration of applications for 90-day extensions of investigations filed by the investigative division, a review of motions in the investigative matters to discuss personnel matters, and the consideration of the signed or reviewing commissioner's recommendation to terminate certain preliminary inquiries. And now the announcement of the public meeting pursuant to the Public Official and Employee Ethics Act 170 of 1978 as amended by Act 9 of 1989 on June 26, 1989, and as amended by Act 93 of 1998. The State Ethics Commission is specifically mandated to hold at least 2 public hearings each year, of which at least one shall be held in Harrisburg and at least one shall be held in a location other than Harrisburg, to specifically seek input from persons and organizations who represent any individual subject to the provisions of this act and from other interested parties. We have placed on the agenda for today's public meeting a notice that the Commission will be meeting today in part to receive the input or testimony of said individuals pursuant to the provisions of the law. As our previously published notices indicated, the Commission will request copies of any statement that is presented. The individuals presenting statements before the Commission will be allocated 15 minutes in order to complete their statements. Statements shall be uninterrupted, except that such statements may be interrupted or terminated by the presiding officer if it is determined that the statement is impertinent, scandalous, or otherwise improper. Okay, with that, we will begin. And first is, can I have a motion to approve the April 7, 2016 public meeting minutes?
So moved.
So moved by Judge Lewis, seconded by Melanie DePalma. All those in favor signify by saying aye.
Aye.
Nay, the ayes have it. The second item, Gorham opinion, Roger Nick.
Thank you, Mr. Chairman. The facts pertaining to this advisory request are as follows. The requester is the Honorable Elizabeth A. Gorham, Mayor of the Borough of State College. The borough is a home rule municipality operating under the terms and provisions of the Borough of State College Home Rule Charter. Mayor Gorham is currently evaluating the possibility of charging a monetary fee for performing marriage ceremonies as borough mayor. Mayor Gorham notes that recently various state statutes have been enacted that allow mayors to charge for performing marriage ceremonies, but none of these statutes specifically mention home rule municipalities. Mayor Gorham asked whether she would be permitted to collect payments, honoraria, for performing marriage ceremonies. I note that Article 4, Section 405 of the Borough Home Rule Charter provides as follows. Elected officers may receive compensation as shall be fixed by council from time to time, but such compensation or any change therein shall not become applicable to any incumbent officer until the commencement of a new term of office. Mr. Chairman, I would suggest that this would be an appropriate time for any interested parties to speak on this matter. I would also suggest that this might be the appropriate time to go into quasi-judicial deliberations if anybody on the commission wants to debate it. I mean, I don't know, or just move right ahead of this. Okay. Mr. Chair, I reviewed the facts and relevant statutory provisions. There is presently no provision of law expressly authorizing the mayor of a borough that is a home rule municipality to receive a monetary fee for performing a marriage ceremony. And only a court would have jurisdiction to decide under current law whether Section 10A05 of the Borough Code applies to the borough as a home rule municipality. Additionally, the Borough Home Rule Charter does not expressly authorize the borough mayor to receive a monetary fee for performing marriage ceremonies. In Section 405 of the Borough Home Rule Charter provides that the compensation of elected officials shall be fixed by Borough Council and that a change in the compensation of an elected officer of the borough shall not become applicable to any incumbent officer until the commencement of a new term of office. Unless there is a valid legal authorization for Mayor Gorham to collect fees for performing marriages, she has no legal authority to do so, and unauthorized fees would constitute private financial gain and be prohibited honoraria for purposes of applying sections 1103A and 1103D of the Ethics Act. Based upon my analysis and comments, I would like to make the following motion. I move that the holding of this commission in this matter be as follows. As mayor of Borough State College, Mayor Elizabeth A. Gorham is a public official subject to the provisions of the Ethics Act. Unless there is valid legal authorization for Mayor Gorham as borough mayor to collect fees for performing marriages, she has no legal authority to do so, and unauthorized fees would constitute private financial gain and prohibit honoraria for purposes of applying sections 1103A and 1103D of the Ethics Act. Since the Borough Home Rule Charter and Borough Council has not expressly authorized the borough mayor to accept payments for performing marriage ceremonies, the Ethics Act would prohibit Mayor Gorham from accepting payments for performing marriage ceremonies unless, 1, Section 10A05 of the Borough Code applies to the borough, and 2, Mayor Gorham's acceptance of payments for performing marriage ceremonies would occur in a manner that would comply with both Section 10A05 of the Borough Code and the Borough Home Rule Charter.
Second. I have a question, I guess a legal question. Let's assume that this mayor, performs a ceremony, and the fellow says, gives him $100. Says, listen, I really appreciate you coming out here. It was snowing and it's a bad day and all that. And he takes the $100. And if someone, would claim that he should have not done this, would the mayor be in trouble?
Yes,
Okay.
because it's not just conflict of interest 1103A, it's the prohibition against honoraria. And you just simply can't accept them unless there's some legal authority allowing for it.
Okay, you made a motion, who seconded?
Mark seconded.
Mark seconded. All those in favor, signify by saying aye.
Aye.
Okay, the ayes have it. Item 3, Melanie.
This is the case regarding two civil penalty orders for consent, with consent agreements regarding Reisinger 15-002-P and Bucaramanga 16-023-P. These cases involve respondents Kristen Reisinger and Marie Ame Mukarangia. Respondent Reisinger failed to timely file a statement of financial interest for calendar year 2013. Respondent Mukarangia failed to timely file a statement of financial interest for calendar year 2014. In each case, the parties have submitted a consent agreement proposing that the commission find that the respective respondent failed to timely file a complete and accurate statement of financial interest for the aforesaid calendar year and impose one civil penalty in the amount of $250. Respondent Reisinger has not paid the recommended civil penalty or filed the delinquent form. Respondent Mukarangia has paid the recommended civil penalty but has not yet filed the delinquent form. Based upon my review of the facts, I'm of the opinion that these consent agreements are consistent with commission precedent and are proper dispositions for these cases. It is my opinion that the commission should order respondent Reisinger to pay the recommended civil penalty agreed to by the parties per the consent agreement. It is further my opinion that the commission should order these respondents to file their delinquent statements of financial interest, as there is nothing of record that would constitute a defense or excuse for their noncompliance. Mr. Chairman, based upon my analysis and comments, I would like to make the following motion. I move that this commission approve the consent agreements submitted by each of the following respondents and the investigative division, imposing civil penalties for failure to timely file statements of financial interest as follows. Kristen Reisinger, $250 for calendar year 2013. and Marie Ame Mukongarupia, $250 for calendar year 2014. I further move that Respondent Reisinger shall be ordered to pay the recommended civil penalty agreed to by the parties for the consent agreement within 30 days of issuance of the Commission's order. Further, these respondents shall be ordered to file their statement of financial interest for the year stated within 30 days of the issuance of the Commission's orders. Mr. Chairman, that is my motion.
Second, Roger?
I just have one
Yes,
question.
sure.
Is this the first, failure to file for each of these respondents?
Yes, this is Reisinger's first. She has another one, what was it? That we actually withdrew. And the other lady, also, it's first time.
First time?
I have a question. Especially if this is the second time, this Kristen Reisinger as a hearing examiner presumably is a lawyer. You know, the Supreme Court is rather quick with us if we don't even complete our continuing legal education courses. And here she is, she got 5 letters, presumably, 3 from the governor's office, 2 from us, all the time, effort, and expense. And as a lawyer, she's ignoring the law. And I'm wondering, do we report this to the disciplinary board?
We could do that. We could forward the order.
I think when it's a lawyer, we ought to do that.
What? We didn't even vote on it yet.
No.
All those in favor of the motion, say aye.
Aye.
Nay. Okay. Item 4, civil penalty orders, defaults, Judge Lewis.
Before we get started, I just want to note for the record that I'll be abstaining from the vote on the matter regarding Joshua Schiavone.
And Judge Lewis, can you do 2 separate motions then, just to facilitate that?
All right. There are 16 civil penalty default cases that are now before this commission for decision. The respondents involved in these cases will be identified individually in the motion making with regard to these cases. However, in light of Commissioner DePalma's abstention and not voting or participating in one of these, I will be making a separate motion as to that particular civil penalty order. In each case, the respondents failed to file a statement of financial interest for calendar year 2014. These respondents did not take action or respond to the civil penalty proceedings. Following review, it is my opinion that as to each of these respondents, the commission should levy a maximum penalty of $250 for the delinquent statement of financial interest. It is my opinion that the commission should also order these respondents to file their delinquent statements of financial interest. There is nothing of record that would constitute a defense or excuse for their noncompliance. Based upon my analysis and comments, I would like to make the following motions. First, I move that this commission levy a maximum civil penalty in the total amount of $250 against each of the following respondents for failing to file a statement of financial interest for calendar years 2014. Edwin Price, Rebecca Harris, Caleb Wilt, Luke Conrad, Lisa Green, Brett Fromm, Diane Robinson, Joseph Yates, Frank Yaconic, Jeffrey Boyd, Leah LaHovey, Carlotta Janice Pendleton, Nydia Diaz Neal, Michelle Teresa Williams, and Corey Rana. Further, these respondents shall be ordered to file their statements of financial interest for calendar year 2014 within 30 days from the issuance of the commission's order.
Second.
Second by Maria, okay. All those in favor signify by saying aye.
Aye.
Nay. Ayes have it.
Next, I would move the commission levy a maximum civil penalty in the amount of $250 against the following respondent for failing to file a statement of financial interest for calendar year 2014. Joshua Schiavone. Further, this respondent shall be ordered to file his statement of financial interest for calendar year 2014 within 30 days from the issuance of this commission's order.
Okay, motion by Judge Lewis, second by Mrs. Sweeney. All those in favor signify by saying aye.
Aye.
Nay. The ayes have it. Okay, civil penalty orders contested, Mr. Corrigan, would you read those?
Yep, there is one contested civil penalty case that is now before this commission for decision, and the case involves respondent Eric Frombach, a real estate appraiser with PennDOT, who failed to timely file a statement of financial interest for calendar year 2013 with PennDOT. The respondent filed a delinquent form with this commission after the civil penalty proceedings were initiated against him. The respondent also filed an answer to the show cause order, asserting that there are mitigating circumstances in this case and that a civil penalty should not be levied against him. Respondent requested a hearing that he would not be required to attend. Although our chief counsel issued a letter to respondent stating that failure to attend the hearing could result in adverse legal consequences for his cause, respondent did not attend the hearing, which was held on April 5th, 2016. The meeting materials that all the commissioners received include the parties' pleadings as well as the hearing record. It is my view that the evidence establishes that respondent failed to comply with section 1104A of the Ethics Act when he failed to timely file his statement of financial interest for calendar year 2013. There is no evidence whatsoever of record to support respondent's assertions of mitigating circumstances. In fact, the record contains much evidence of what I would consider aggravating circumstances. This action is for failure to file for calendar year 2013, but he also failed to file for calendar year 2012, but that is not currently before us. Insofar as calendar year 2013 is concerned, 3 separate letters were sent from the governor's office on February 3rd, June 9th, and July 1st, 2014, advising him to file. Nothing was filed. This commission then sent him a letter on August 25th, no filing from Mr. Frombach. This commission again sent him a letter on October 21st with no result. Finally, on December 31st, almost 2 years later, this commission issued an order to show cause. It was only at that point that Frombach did file his statement with us on January 28, 2016, and also requested a hearing, which he did not attend, although strongly advised to by our chief counsel. Based upon my analysis, I would like to make the following motion. I move that the commission levy a maximum civil penalty in the total amount of $250 against respondent Eric Frombach for failing to timely file a statement of financial interest for calendar year 2013 with the Pennsylvania Department of Transportation.
Motion made by Mr. Corrigan, seconded by Melanie Palmer. Any questions? All those in favor signify by saying aye.
Aye.
Nay, the ayes have it. Good. The next one, Maria Field, the lobbying.
There are 2 default administrative penalty cases for our consideration. Respondents Somerset Regional Water Resources and Hamilton Development Partners LLC both failed to timely file quarterly expense reports for the 3rd quarter of 2015 as registered principals. The quarterly expense reports still have not been filed as of today. Each is 237 days late. It appears that each respondent's transgression of the lobbying disclosure law is negligent. There's no basis in the records of these materials as provided to the commission for imposing less than a maximum civil penalty against each respondent. Based upon review of the facts as presented to the commission, I move to adopt the recommended administrative penalty orders. More specifically, I move that this commission levy upon Somerset Regional Water Resources and Hamilton Development Partners LLC one maximum administrative penalty each in the amount of $11,850 each, calculated as $50 per day times each of the 237 days their quarterly expense reports for the third quarter of 2015 have been delinquent. I also move that Somerset Regional Water Resources and Hamilton Development Partners LLC be ordered to pay these administrative penalties no later than the 30th day after the mailing date of this commission's orders, and that they be ordered to file with the Pennsylvania Department of State their quarterly expense reports for the third quarter of 2015 no later than the 30th day after the mailing date of this commission's orders.
Motion by Maria Feely, seconded
Second.
by Judge Lewis. Questions?
We've gone straight to the maximum per day penalty for these because they are so egregious.
Primarily because they defaulted, they didn't respond to any of our attempts to get them to file.
When does negligence become intentional?
If it becomes intentional, you have to send it to the Attorney General, and you cannot impose an administrative penalty. That's just the legal point on it.
Because they still haven't filed, it's 200 and some odd days. Okay.
Any other questions? All those in favor of the motion signify by saying aye.
Aye.
Nay, the ayes have it. Final matter is the administrative matters, and we have Judge Lewis.
Pursuant to the Sunshine Act, official action as to personnel-related matters shall be taken at an open meeting. Accordingly, I move this commission approve and/or ratify the following actions regarding commission staff. 1, ratification of a 2.25% pay increase for all commission staff effective January 1st, 2016, in accordance with the Commonwealth Pay System for management employees. 2nd, the promotion of Letitia Powell to the position of Director of Administration and Management, Pay Scale Group 7, Level 10, effective April 30th, 2016. The promotion of Sean Firestein to the position of IT Manager, which is an IT Generalist 2, in Management Pay Scale Group 8, Level 15, effective April 30th, 2016. And the promotion of Senior Assistant Counsel Martin Harder to the position of Attorney 3 in Management Pay Scale Group 10, Level 8, effective April 30th, 2016. Mr. Chair, that is my motion.
Second.
Second.
Second by Mark Corrigan. Questions? All those in favor signify by saying aye.
Aye.
Nay? The ayes have it.
There's one, Ms. DeShula is here who would like to address the commission.
Sure. You may proceed.
Yes, thank you, sir.
Before she begins, Mr. Chairman, could I ask counsel, any remarks that Ms. DeSholo makes will be part of the permanent record, right? This is being recorded?
It is
Yes.
being
Right?
recorded.
Just so that you know that, I just want to.
That's,
Okay.
that's fine.
Would
Thank you very much.
Would you give us your name and?
Yes, my name is Karen DeShula. I am the former business administrator for the Coatesville Area School District. And I'm here to speak with you this morning, and I thank you for your time. I'm here to speak with you this morning about the Tanya Thames Taylor investigation and how my name and reputation was besmirched in your report.
I'm sorry, just before you begin, I know at the outset of the meeting, there were certain time constraints based on presentations. I don't know if Ms. DeShula has been advised of those.
I did by email advise Ms. DeShula that she would have approximately 5 minutes to make a presentation to the commission.
Okay.
Can you spell your name?
Okay, sure, as long as this is not part of my time, but yes, the last name is DESHULLO.
Okay, you may begin.
Great, thank you very much. So I am the former business administrator of the Coatesville Area School District. I was in that position a very short amount of time, based on reports made to me and observations, I conducted an internal investigation of the facts and circumstances and dealings within the district, its superintendent, board members, etc. I reported it to various agencies, including the State Ethics Commission. My phone records documentations will show calls made to the State Ethics Commission. I reported to the Auditor General's Office, Attorney General's, Auditor General's Office, FBI, State Police, various law enforcement agencies, including the District Attorney's Office. This is a message
Enter your password.
that I received back from
You
Special
have
Investigator
Safe.
Harry Bassler.
First safe voice message.
Mr. Joe, this is Harry Bassler with the State Auditor General's Office up in Harrisburg, Pennsylvania. I spoke with you back on Monday this week concerning some issues that you had were trying to bring to our attention. Calling to see when you might be available for a in-person interview at your convenience. I'd like to set something up relatively soon so we can start to address.
I met with the auditors from the Auditor General's Office. I made reports to Special Investigator Harry Bassler. Unfortunately, probably because of politics, shortly thereafter, Mr. Bassler and the head auditor on the Codesville matter both lost their jobs. That is a whole other story. Okay, my reports were completely ignored. There has been a report, however, since involving Tanya Thames Taylor, and in that report, there are a number of falsities. One is that, and when I called about it, I was told that I have no standing. And I submit to you that I have perfect standing, as my name is mentioned in the report. I am someone who is absolutely called out, not by position, but by name in the report. And there were a number of falsities, including one in which that I did not do my duty to ensure that Tanya Thames Taylor's husband did his work for the Codesville Area School District before a payment was made out. I had confirmed with the superintendent that the work was done. Also, I had made a visit to the technology suite to observe that her husband was in fact was present and working on Codesville matters. So I would submit that I don't know what more I could have done to ensure that the work was done. In my position, I should not have been expected to go out and confirm that every single teacher was teaching a class to ensure to act as proof as that the teacher should have deserved to pay for the day or a salary. I did my due diligence and I collected the information that was presented to me that the work was done. I did look into a number of matters. My name is actually, well, my name isn't, but my position, and you can see myself referred to in the special investigation report that Conrad O'Brien Law Firm did on the district's matters. I am listed as the prototypical example of what could happen to you if you crossed Mr. Como. And my internal investigation is mentioned, and I am portrayed as such because it was true. I was doing my absolute due diligence in trying to find out what was going on in that school district, and I made all of the reports in the proper fashion, which was difficult to do because you didn't know who was in with who and who could convey your position and the things that you were looking into at any point in time. There was also another inaccuracy in the report that Mr. Leupold was not the board secretary. I submit to you that he was the board secretary. There was no board secretary appointed officially via Robert's rules. You can look in Codesville's records and their minutes, and you'll see that Mr. Leupold is still secretary, was still secretary at the time. Shall I go on? I just would submit that you should look into correcting this report in its inaccuracies. I think that that is the decent thing to do. I know that this commission has gone on record before, especially in the James Ellison case, as it relates to the Harrisburg Authority, that it was limited, and it's limited by what people report on their statement of financial interest forms. And indeed, I was told that when I called the Ethics Commission, that's what, it's limited to. However, I would submit that if you feel that you're limited, at least what you can do is correct this report when you do know that there are inaccuracies. And I could go on, and I would just offer that I would be most cooperative with meeting with the commission or any of its members to go into the dealings of Mr. Ellison and the Harrisburg Authority and how Coatesville Area School District lost over $2.1 million over the years, and a complete conflict of interest, and the other matters with the Coatesville Area School District. So I am available to meet with you at any time. And I thank you for your consideration.
Any questions?
Well, thank you very much for your time, and I do appreciate your input very much.
Thank you.
Thank you.
Having no more business, have a motion to adjourn. Kelly makes a motion, seconded by Mark Carden.
Well, I want to do more business.
Oh, you do?
You can stay all day.
All those in favor signify by saying aye.
Aye.
Guys,
I'll suggest the absence of a quorum.